Welcome to Guardians of Innovation, Patent and Trademark Law.
Welcome to Guardians of Innovation, Patent and Trademark Law, the podcast where we dive into the world of intellectual property and protect the ideas that shape our future. I am your host, Kevin Rosenquist, and today we're tackling an essential question for inventors, entrepreneurs, and creators. How does an attorney protect an idea or product? We're going to explore the strategies and legal tools used to safeguard your intellectual property from patents to trademarks, and how having the right attorney on your side can make all the difference in protecting your hard work. And of course, as usual, I am joined by Vincent LoTempio. Vincent, so great to have you here.
Hey, thanks, Kevin. I appreciate your help in all these podcasts. It's been a lot of fun working with you.
Absolutely. No, I love talking about this stuff. It's really fascinating. So let's start with what we were talking about inventors. What's the first step that an inventor should take when they come up with a new idea to ensure that it's legally protected?
Yeah, to ensure that it's legally protected, you want to document your invention in detail and have a record that you conceived it and how you conceived it. Usually I say, let's put together an inventor's notebook, and date it every time you think of something. Keep it by your bed in the middle of the night and write in it. One of the first times an inventor's notebook was used in a court of law, his name was Philo Farnsworth. Do you know who Philo Farnsworth was?
I don't.
You should know this, and I think everybody should know this. He's the guy who invented the television. Everybody remembers who invented the radio. Nobody remembers who invented the television. But he was just a high school kid living on a farm, and he was in his class, and he had a notebook, and he wrote down how he was on the farm, and he saw these lines of definition, which I still can't figure out how the hell he did that. And he put it, into his high school class, and he invented the television. And then, of course, the big companies, they want to steal your idea. And who's the big company? The microphone with the dog listening, the old Victrola, those old Victrolas.
Oh, absolutely.
So, yeah, but that was RCA, right?
RCA, that's it.
RCA, yep. They're dominating the radio. Now they want to dominate the television. And their whole defense was, he's only a high school kid. How the hell did he invent this? And then he pulled out his notebook and showed him how he did it, and he won the case. So my advice to the inventor is write down every detail of your invention, how it works, what problems it solves, the steps involved in its creation and operation, any alternative designs or different ways you can use the same thing, include diagrams, sketches. If you have prototypes, take pictures of it. Date and sign the documents as you come up with it. If you present it to somebody like me as a patent attorney, write down in the next page, spoke with LoTempio today, the patent attorney, told him my invention. So if we ever have to prove that it's your invention, you could use that as a, proof, piece of evidence in the future. Okay. And it helps you, get better at detailing what exactly your invention is. So many times an inventor's mind will just fill in the blanks, right? And he'll think that it's so obvious. But when you start writing it down, things pop out that aren't so obvious in you. That'll definitely help me as the patent lawyer to write the patent application out. You don't know how many times where we'll be in an argument with an examiner trying to get the patent, and they'll say, well, if it had this, then maybe that would be patentable. And then the client says, yeah, it has that. I go, where does it say that anywhere? Where did you tell me it had that? And they never did. And it never made it in there. So I always say, give me as much detail as possible.
To them, it's obvious. To the rest of us, it's not. Yeah.
Yeah. I mean, I was a trial attorney, right? When I first got out, I was working in the district attorney's office doing jury trials. And I remember talking to a witness, and I was prepping him to go in there. And I'd ask him, did you come in the room? Yeah. Well, did you open the door to get in the room? He goes, yeah, it's obvious I opened the door. I go, no, it's not obvious unless you tell me in words when you're up on the stand that you opened the door. It's like painting a picture of the sunset and leaving a white part of the canvas on there and saying, well, it's obvious the sun's there. No, you still have to paint the sun on the canvas. Mm-hmm. So the more details, the better, right? So then the next step is conduct, a review, make sure that anybody that you talk with, that you have a non-disclosure agreement. You don't want to publicly disclose your idea. My goal, especially when we work with bigger corporate clients where things are, and everybody thinks that their idea is going to be the next selfie stick, right? And it's going to be worldwide. And, I actually worked with the guy who invented the selfie stick. And I ended up getting on a show called The $1 Million Genius talking about his invention. And I always say, you just never know. It could happen to anybody. It happened to Wayne Fromm, the inventor of the selfie stick. If the selfie stick, it could happen to you. But you don't want to jeopardize your rights by not filing in time. So my advice is always to file it before you show it to anybody. But if you have to show it to somebody and you think this is a deal that has to be made, make sure you have a non-disclosure agreement, and then you get it filed as soon as possible after that. One of the things that we do to make sure that it's worthwhile to file is doing a patentability search. And so, in our patentability search, we want to assess whether it's new, novel, it's useful, it has utility. And a lot of times you'll hear what's the difference between a utility and a design patent, and I always say, I use the Coca-Cola bottle, although I don't have a Coca-Cola bottle in front of me. I have, just this bottle by Poland Springs, but it's got a unique shape to it, right? This is the way it holds and the way it does. That's the design of it. The utility is what? It holds a liquid, right? It's got a utility. That's what's usefulness. So we have to show that it has usefulness. And then finally, there has to be a non-obvious improvement. So what we'll do is we'll search all other patents, see if anything like that's out there. Chances are it's going to be novel. No one's ever made a bottle exactly like that. Chances are it's useful. It'll actually hold water and you could drink out of it. And then the question is it obvious improvement or non-obvious? And that's always the question that the attorney has to give an opinion. And that's always the argument when it comes down to getting the patent off, with the patent office getting the patent. So there's two different types of patent applications you can file. There's a provisional, non-provisional. So, a provisional is something that just holds the filing date, right? So a provisional lasts for 12 months. It gives you a chance to go out there and try to market it right away without having to lose the race to the patent office. Because what happens is it used to be the first person to file the application wouldn't matter if somebody else can prove that they invented it first. But that rule has been changed now. Now the rule is the first to file. So that's why it's so important to file it quickly. And that's where a provisional application could help you establish a date without having to file a full-blown application like the non-provisional. And then of course, you have to develop your own strategy, trademarks, copyrights, trade secrets, and how to protect the idea. Just real briefly, trademark is for branding, it's marketing. Copyrights are for more of like works of art to stop people from copying it. And then trade secrets, are kind of like, like the Coca-Cola recipe. Look, you can try to reverse engineer it, but I'm going to keep it secret. I'm not going to try to patent it because if once I show it to somebody, it's only good for 20 years and they could just make it. So those are strategies of how you can protect it outside of a patent. So at the end of the day, you want to try to have a strategy from going in and what you want to do and have an attorney like myself help you fulfill those goals that your strategy has come up with.
How does the patent process differ from new inventions versus improvements on existing products?
Basically, it's the same thing because, new inventions always have something in it. I always say, that's here, say there's billions and billions of things on the planet, billions of elements, right? And I equate those things to the keys on the piano. So when you put together your table, there's four legs and there's a tabletop. It's just a flat piece of wood. Those are things that are out there. And now you're going to put them together and you're the first caveman to come up with the table, right? So the question then becomes, out of those finite elements, all the elements in the world, the billions of things, and we're just going to say they're all there on the piano keys. Are you playing Beethoven? Are you just playing chopsticks? Or are you just banging the keys, right? It's how creative that you're going to put it all together. Now you got the table that's got a top, a bottom, and four legs, but you've come up, your name is Archimedes, and you've come up with an idea that if you make the table legs have an arc, they're going to be able to hold 7,000 more pounds. But so now there's an improvement on the table already. So I'm not going to be able to get a patent on the table. In fact, if somebody already has the patent on the table, a top, a bottom, and four legs, and I'm making these curved legs that can hold 7,000 more pounds, I still can't even make my own table because I'm going to be infringing on this other guy's patent. So, there's a lot of, crossover when you're doing it, but essentially every patent is written the same way. there's a problem out there. People in the past have tried to solve this problem. This is how they failed, and this is how I do it a little better.
What role does a registered patent attorney play in the application process? And can you kind of talk about why, you feel it's crucial to work with one?
Well, I mean, you always heard in life, a lawyer that represented themselves got an idiot for a client. And it's same thing. If you're going to go to a doctor, you're not going to sew up your own arm, right? You're going to go to a doctor. So anytime you want to do anything, using a professional expert in that area makes sense. Don't try to do it yourself. And I have so many clients that are engineers that have so many patents, and they work for corporations, and then they want to get their own patent on their own, and they think they're going to write it themselves. And, quite frankly, they do a pretty good job, but they're missing a lot of the intricacies of the patent itself. So, when you're working with an inventor, you want to be able to communicate with them to a point where they understand and they can assess your invention, right? From its functionality. I always say it's both. You have to look at structure and function. So you have to describe how to make it and what each one of those parts do, right? And then determine what are the novel aspects of it. So as far as drafting the application, I just remember my experience as a patent attorney when I first started 25 years ago compared to what I can do now. And even then, compared to somebody that's never been trained in this, it's like night and day. And so many times people think they have this great patent that they want me to review and just file it because they don't want to pay the money for me to write the whole thing. And I look at it and say, again, it's like going to a house builder and say, look, I started to build a house myself. Could you come and take a look at it and see if you could help me? And I get there and the roof is in the basement. I'm like, look, there's nothing I can do to help you here. We have to start over from scratch. So the attorney helps you navigate the patent law. It helps you, we communicate with the patent office. We know exactly what they're looking for. I mean, so many times, there's been communication with the patent office between the pro se person that wrote his own patent, that the person keeps saying the same thing over, but they don't understand what the legal intricacies are, and they're just way off base, and it just frustrates the examiner. And chances of you getting through that is very difficult, And then, of course, once you have the patent, who's going to defend it, right? After the patent is granted, the attorney can help you enforce your rights, sending out cease and desist letters, determine whether or not there is a validity of a defense if somebody's suing you on it, and whether you can sue somebody else. So, working with a patent attorney, you want the expert knowledge, the success rate of the attorney, the cost effectiveness of the application. It's sometimes for $250 we can get drawings done, and then the client says, I don't want to spend $250 on the drawings. I could draw it myself. And then it spends hours and hours of time just trying to get the drawings to look right. And then they get rejected. So the attorney helps you just to direct you in the right direction and make sure that you have comprehensive protection for your patent. And to do it yourself, it's like being your own doctor.
Kind of piggybacking off that, what are some more of the more common mistakes you see inventors make when trying to protect their ideas, and how can you help make sure they avoid those?
Well, one of the things I always say, look, don't show it to anybody. Keep it secret until we get something filed. So this public disclosure, one of the things that they try to meet with investors, there's this new thing, it's probably not new anymore, but Kickstarter, I'm sure you've heard of Kickstarter, and they're trying to get money for it. You could lose your patent rights, if somebody else files it before you. And there's a rule that basically says that if you use it in public, you offer it for sale, or you publish it anywhere within 1 year from the time that you file the application, you lose all your rights. So there was a Facebook case, where somebody invented some aspect of what Facebook did, and they sued them. And it went to a jury trial. And the jury decided that, yes, Facebook infringed on this patent, but they also concluded that the owner of that patent went out and tried to sell his idea more than a year prior to the date that he filed his application, and they basically canceled his patent. So I can't imagine fighting Facebook into a jury trial, how many thousands or hundreds of thousands of dollars it cost to get to that point, and then just to lose, all because they disclosed their idea prior to filing the application. So that's the key, So, we don't want to wait too long. We want to file it as immediately as we can. We want to make sure we have, the right documentation, everything that's filed correctly. And, you just want to, the patent search that you work with an attorney, those are all some things that people try to do on their own that ends up kicking them in the butt.
How can an attorney help entrepreneurs navigate the potential risks of infringing on someone else's intellectual property?
Yeah, the big thing there is you have to audit and do searches, right? You want to know what's going on. It's almost like the Army where they do surveillance on the enemy, right? We want to know what's going on out there. We don't want to get ourselves, or our backs up against the wall. So
Sure.
Trademark searches, patent searches, copyright clearances, make sure we're not putting something out there that's going to give them ammunition to come after us. Your attorney could give you IP strategy, come up with IP strategy and how to use the marks and what to do. I actually, conduct, classes within corporations and try to educate, the research and development and the marketing teams on what is patentable, what we can do and what we can't do. So, educating yourself on what's out there is very important. And of course, there's contracts that you have with other companies. We talk about licensing contracts, maybe even settlement agreements if there is some sort of, cease and desist letters going out there that we can work out, just keeping out of court. My goal is always to keep you out of court. Do things prior to getting sued or suing to somebody, because at the end of the day, who wins by getting things in court is the attorneys. They're the only ones that makes money. So, and not that I'm against making money, but my job is to zealously protect you and do the best thing for my client. So I like to fix things before they go wrong. So those are all types of things that we can do, educating ourselves, monitoring what's out there, and be prepared and ready to defend against those claims.
Awesome stuff. Well, thank you for joining us on Guardians of Innovation, Patent and Trademark Law with registered patent attorney Vincent LoTempio. To connect with Vincent, check out lotempio.law.com, and please be sure to like and subscribe to our channel and leave us a review. Vincent, always great chatting with you. Thanks so much for being here.
Thank you for helping me. I really appreciate it.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.